Today, we're diving into a fascinating legal puzzle from over a century ago in what was then called Ceylon, now Sri Lanka. It all kicks off with one single insult, right in the middle of a courtroom. But this wasn't just any insult. It ended up putting an entire legal system on trial and forced a court to answer a really fundamental question about justice itself. Let's get right into it.
So the whole story really boils down to this one question. And believe me, the answer is complicated. Can you be sued for what you say in a courtroom? Just picture it. You're on the witness stand, under oath, you say what you believe to be the truth, and the next thing you know, you're slapped with a defamation lawsuit. Is that even possible? Well, that's exactly the question we're going to unpack today. All right, here's how we're going to break this down. We'll start with the slanderous words that sparked this whole thing. Then we'll get to know the people at the center of the case, Silva versus Balasuriya. After that, we'll see how two completely different legal systems went head-to-head. We'll explore the judge's incredible logic in his final verdict, and then we'll wrap up with this really profound idea about how old laws can sometimes just fade away.
So let's set the scene. The year is 1911. We're in the District Court of Matara, Ceylon. There's a trial going on, something about a financial dispute. Seems pretty ordinary. But then, a witness gets on the stand and says something that is going to cause a legal earthquake, one that will be felt all the way up in the Supreme Court.
And there it is. Those are the words that started it all. A witness, a man named Balasuriya, points to another man, Silva, and calls him a burglar who isn't even allowed in their homes. Now, in a society where your reputation is basically everything, this is a huge public blow. Silva knew right away he couldn't just let that slide. So he did what anyone would do. He decided to sue. And that action brings us to the pivotal court case that would actually change the law in Ceylon forever. See, this was way more than just a personal insult. This was about to define the very rules of how a courtroom operates. Let's meet the key players. Okay, so on one side, you've got the plaintiff, Silva. He's arguing that his good name, his entire reputation, has been destroyed. And on the other side, you've got the defendant, Balasuriya, who says, hey, I was a witness in a court of law. His defense was pretty simple. Anything said during testimony is shielded, it's protected. But was that really the law in Ceylon at the time?
Now, this is where things get really interesting. This case, Silva versus Balasuriya, wasn't just about two men. It was actually putting two massive legal traditions on a collision course. The old Roman Dutch law, which had been around for centuries, and the newer English law brought in by the British. So here's the heart of the conflict. Under the old Roman Dutch system, a witness had something called qualified privilege. This meant you could be sued for what you said, but only if the person suing you could prove you had animus injuriandi, basically a malicious intent to cause harm. English law, on the other hand, was way more straightforward. It gave witnesses absolute privilege, total immunity. What you say in court stays in court, period. The judge had to figure out which system to follow. Silva's lawyer, a Mr. Sampaio, argued passionately for the old way of doing things. He was basically saying, look, Roman Dutch law is the law of the land here. The judge made a huge mistake by not even giving us a chance to prove that Balasuriya said what he said out of pure malice. He was fighting for his client's right to defend his honor under that traditional system. But Balasuriya's lawyer, Mr. Bawa, came back with this really powerful argument about public policy. He argued that if witnesses are constantly looking over their shoulder, worried about getting sued, they'll be too scared to tell the whole truth. He said that for the entire justice system to work, witnesses have to be able to speak freely, without that fear hanging over them. That made the English rule of absolute privilege not just a good idea, but essential. So the stage was set. You had two powerful arguments. Two completely different legal worlds clashing, and the decision on who was right fell to the Chief Justice of the Supreme Court, a man named Lascelles. So, how did he figure this out? The verdict was clean, it was decisive. The court sided with Balasuriya. English law was going to be the rule. From that point on, witnesses in Ceylon were protected by absolute privilege. But, the reasoning behind the decision is what makes this case so legendary. It wasn't just a simple coin toss between two options. The Chief Justice laid out his logic so brilliantly. First, he dug into the history books and found, well, nothing. There was no record of a witness ever being successfully sued for something they said on the stand in Ceylon. Second, he just looked around and observed that the courts were already acting as if the English rule was the law. It was the established custom. That meant the old Dutch law was totally inconsistent with what was actually happening on the ground. And finally, he locked in that crucial public policy argument. You absolutely have to protect witnesses from fear if you want to get to the truth.
And this quote right here, it just perfectly captures the real-world thinking behind the verdict. The Chief Justice pointed out that people in Ceylon tended to sue each other a lot. He was worried that if he allowed this kind of lawsuit, it would just open the floodgates. Every trial could spin off into a dozen new defamation cases, and the whole justice system could grind to a halt. It was an incredibly practical decision for that specific time and place.
So the verdict established absolute privilege. That's clear. But in the process of doing that, the court actually did something even more profound. It laid out a roadmap for how a law, even one that's technically still written down somewhere, can just stop existing. And this is the core legal idea right here. Abrogated by disuse. It's this concept that if a law is never used, if it's never enforced by the courts, and if it's totally out of sync with how society actually works, it effectively dies. It becomes a kind of legal fossil, a historical artifact with no real power anymore.
Let's just walk through how the court used this idea. First, they said, okay, yes, we acknowledge that this old Roman Dutch law technically exists. We're not pretending it doesn't. But then they observed that the actual practice, what people in courts were doing every day, was the total opposite. They noted the Supreme Court had never once upheld this law. And so their final step was to conclude that the law was no longer valid. It had been repealed not by a new law, but simply by being ignored for so long. So what's the big takeaway from all of this? The case of Silva versus Balasuriya teaches us something really fundamental about how law works. It's not just some dusty old book of rules that never changes. It's a dynamic, living system that has to reflect the customs, the practices, and the real-world needs of the society it's supposed to serve. And when a law stops doing that, it can just fade away. And that kind of leaves us with one last question to think about. This whole idea of a custom replacing an official rule doesn't just happen in a courtroom back in 1911. Think about your own world, your job, your friend group, your community. What are the unspoken rules, the established ways of doing things that have become way more powerful than any official policy written down in a handbook? It's a pretty fascinating thought. Thanks for joining us for this explainer.